Ari, and belated happy birthday wishes. Yesterday was Ari's birthday. Welcome everyone to our annual Supreme Court Year in Review with Dean Erwin Chemerinsky. My name is Fran Salmore-Gustin, and on behalf of Ari Katz and the entire CSP board, I want to welcome you to today's program with our very favorite Supreme Court analyst, Erwin Chemerinsky, the current Dean of Berkeley's Law School and the founding Dean of UCI's Law School. Boy, did you change Orange County for the better, Erwin. Today's program is dedicated in memory of Justice Ruth Bader Ginsburg. In the fall of 2019, Justice Ginsburg went to Berkeley and delivered the first Irma Hill Kay Memorial Lecture. Irma Hill Kay was the co-author of Justice Ginsburg's first book on sex-based discrimination that was published way back in 1974. Irma Hill Kay went on to become a professor of law and dean of Berkeley's Law School, which Dean Chemerinsky is now. The lecture and conversations became the foundation of Justice Ginsburg's final book, Justice, Justice, Thou Shalt Pursue. It is the fundamental principle that Justice Ginsburg followed throughout her life. I cannot think of anyone who worked harder to bring those immortal words to life. And like Justice Ginsburg, you, Dean Chemerinsky, have spent your entire life fighting injustice and speaking truth to power. You have continued her legacy. I want to close with a story that one of Justice Ginsburg's clerks shared with us. A few of her law clerks got together and had personal stationery made up for the justice. At the very top, the following words were embossed: "The notorious RBG, you can't spell truth without Ruth. You can't spell truth without Ruth." Words to live by. And now for more words to live and learn by, I want to welcome back Dean Erwin Chemerinsky, our favorite Supreme Court commentator, and the one person who's broken every CSP attendance record. Welcome back, Erwin. We're honored to have you with us again to explain another momentous year at the Supreme Court. Back to you.
Thank you for the kind introduction. It's truly an honor and pleasure to do the program for you again. As you were just saying, you can't spell truth without Ruth. It occurred to me for the first time that I guess we could now say that the Supreme Court is ruthless. That's clearly the biggest change in the Supreme Court from when I talked to you last year. The death of Justice Ginsburg on Friday, September 18th, and the confirmation of her successor, Amy Coney Barrett, on Monday, October 26th. I neither want to overstate the significance of the shift nor underestimate its importance. I think that a statistic from last year, October term 2019, is particularly revealing. A year ago, the Supreme Court decided 53 cases with signed opinions after briefing and oral argument. 14 of the 53 cases were 5-4 decisions. In 10 of those 14 5-4 decisions, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. Everyone believes that Amy Coney Barrett is going to be a very conservative justice. She was a conservative law professor at Notre Dame. She was a conservative federal court of appeals judge in Chicago. She said that Antonin Scalia's judicial philosophy is her judicial philosophy. Had she been on the court last year rather than Ginsburg, those 10 cases likely have been 6-3 rather than 5-4. Replacing Ginsburg with Barrett would have changed the margin, but not the result. And we're seeing a lot of 6-3 cases this year, not surprisingly. On the other hand, last year, of those 14 5-4 decisions, there were 2 where the majority was Roberts, Ginsburg, Breyer, Sonora, and Kagan. Had Barrett been on the court rather than Ginsburg, those 2 cases likely would have come out different. They were important ones. One case involved the court striking down a Louisiana law imposing restrictions on abortion. Another involved the Supreme Court saying that President Trump could not rescind DACA, the Deferred Action for Child Arrival program. There had been a number of cases where Roberts was with the liberals in the majority. In 2012, the Supreme Court upheld Obamacare, the Patient Protection Affordable Care Act, in a 5-4 decision, with Roberts joining with Ginsburg, Breyer, Sotomayor, and Kagan. 4 justices would have declared the entire Affordable Care Act unconstitutional. And a Notre Dame law professor, then by the name of Amy Coney Barrett, said she believed that the Supreme Court was deeply flawed in upholding Obamacare. Now, with Justice Ginsburg replaced by Justice Barrett, it's much harder for the liberal justices to be in the majority. Simple arithmetic explains why. They need to get 2 votes rather than 1. And on a court where there are 5 staunch conservatives, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, are as conservative as any justices who have served on the Supreme Court. And John Roberts is a moderate conservative justice. Maybe the most important thing that I have to say to you this afternoon is that this is not a short-term phenomenon. Amy Coney Barrett was 48 years old when she was confirmed on October 26th. If she remains on the court until she's 87, the age was Justice Ginsburg died, Barrett will be a justice into the year 2059. When Barrett was confirmed, Neil Gorsuch was 53, Brett Kavanaugh was 55, John Roberts was 65, Sam Alito was 70, and Clarence Thomas was 72. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. Remember, John Paul Stevens didn't retire until he was 90. Justice Ginsburg just died at age 87. So I think we will have a very conservative Supreme Court for another decade or maybe 2. Well, that's the context we're talking about this October term 2020. The Supreme Court held oral arguments in 63 cases. Some of them drop along the way. So I think this year there'll be about 60 cases decided with signed opinions after briefing and oral argument. The court will finish handing down decisions likely towards the end of next week, finishing its goal, having all the cases come down by the end of June. You might remember last year, the court didn't finish until July 12th, but that's because it canceled oral arguments in March and April and rescheduled many for May. This year, they finished the oral arguments as usual in April. What I always try to do in this talk is pick a few of the most important cases, important in people's lives, important for the law, and discuss those, and then save the last 15 minutes for questions. This afternoon, I want to talk about 4 areas of cases. 2 of the areas, the cases have already come down. 2 will be getting the decisions in the next 10 days, but you should be on the lookout for them. Let me start with the cases that have come down. And the first area that I want to talk about concerns, again, the Patient Protection and Affordable Care Act, Obamacare. The Patient Protection Affordable Care Act produced deep partisan disagreement from the very outset. Every Republican in Congress voted against the Affordable Care Act. But the Affordable Care Act has been quite successful. Today, 21 million people get their health insurance through the Affordable Care Act. A little bit of background. I mentioned to you in 2012, the Supreme Court upheld this law. The issue in that case was primarily about whether the so-called individual mandate was constitutional. The individual mandate was the requirement that everyone purchase health insurance or pay a tax penalty. And the Supreme Court 5-4 said this was constitutional. As I mentioned, Roberts wrote, joined by Ginsburg, Breyer, Sotomayor, and Kagan. Chief Justice Roberts said, this is a tax. If you don't purchase insurance, you have to report that on your income tax form. You have to pay a penalty to the IRS. It goes in the federal treasury. Congress, under the Constitution, has broad powers to tax and spend for the general welfare. In December 2017, as part of the tax reform bill, Congress eliminated the penalty for people not purchasing health insurance. There's still a requirement in federal law that people have health insurance, but if someone fails to do so, there's no longer any tax consequences. Texas went to federal court and said, This makes the Affordable Care Act unconstitutional. Texas said the Affordable Care Act was upheld, the individual mandate was allowed because it was a tax. No longer is it a tax. The Trump administration came into the lawsuit to argue the Affordable Care Act was unconstitutional. Usually, the president and the Justice Department defend federal laws. Here they said the entire law should be struck down. California and some other blue states came into the lawsuit to defend the Affordable Care Act. A very conservative federal district court agreed with Texas. The United States Court of Appeals, in a 2-to-1 decision, agreed too, and the Supreme Court granted review. There were 3 issues presented to the Supreme Court. First, does Texas, do the other plaintiffs have an injury to allow them to sue in federal court? If so, second, is the individual mandate unconstitutional because there's no longer a tax penalty? And third, if it is unconstitutional, does that make the whole Affordable Care Act unconstitutional? The Supreme Court on Thursday of last week, in a 7-2 decision, upheld the Patient Protection Affordable Care Act, or more precisely what they did was dismiss the lawsuit, saying that Texas and the other plaintiffs didn't have what's called standing to sue. Justice Stephen Breyer wrote the opinion for the court. The dissent was Justice Samuel Alito, joined by Justice Clarence Thomas. In order for anyone to sue in federal court, you or me or the state of Texas, we have to be injured. This is referred to in the law as standing to sue. And unless somebody has an injury, they've been personally hurt, they don't have standing, and the case can't go forward. Justice Breyer, writing for the court, said, no one is injured in light of Congress repealing the tax penalty. Individuals were part of this lawsuit in addition to Texas, but they're not hurt because there's no consequences if they don't purchase health insurance. Texas isn't hurt by this. Texas claimed some indirect injuries, but the Supreme Court said that's not enough to meet the standing requirement. The result is case is dismissed. Bottom line, the Affordable Care Act stands. Why does this matter so much? We're still obviously in the midst of the worst public health crisis in over a century. As I alluded to, 21 million people are getting their health insurance through the Affordable Care Act. Had the court struck this down, it had an enormous effect on people's lives. This is an unusual Supreme Court case, and that its greatest significance is what the Supreme Court didn't do. It didn't strike down the Patient Protection and Affordable Care Act. There's an article in today's Los Angeles Times by David Savage, where he talks about this seems to be the end of the line for challenge to the Affordable Care Act. Conservative opponents brought so many lawsuits. It's the 3rd time it's gone to the Supreme Court. But now the court has made clear the law is constitutional. The second area of cases that I want to talk about and spend more time on concerns free exercise of religion. I said to you before in these talks that one of the places where we're seeing the most dramatic changes in constitutional law because of the shift in the composition of the Supreme Court is with regard to religion in the Constitution. There's 2 provisions in the Constitution that deal with religion. One is called the Establishment Clause, that there can be no law respecting the establishment of religion. Long ago, Thomas Jefferson spoke how there should be a wall that separates church and state. The idea is that our government should be secular. The place of religion is in our homes, our synagogues, our churches, our mosques. Now we have a majority of the justices who reject the idea of separation of church and state. They believe that the government only violates the Establishment Clause if it coerces religious participation. So for them, religious symbols on government property don't violate the Constitution. Just 2 years ago, the court upheld a 45-foot cross that sits public property at a busy intersection in Prince George County, Maryland. Because from their view, this isn't coercing religious persuasion. A few years ago, the Supreme Court's conservative justices upheld a town in New York, inviting only Christian clergy to deliver prayers, and often very sectarian prayers, before town board meetings. And this was over a long period of time. For these justices, that doesn't violate the Establishment Clause. So as these conservative justices hear Establishment Clause cases, what we're going to see is they're going to allow unlimited religious symbols on government property like crosses, nativity scenes. They're going to allow prayer at public meetings. They're not only allow, but going to require that the government subsidize religious schools when it gives the same aid to private secular schools. The other provision of the First Amendment dealing with religion is called the Free Exercise Clause, that the government can't abridge free exercise of religion. In 1990, in a case called Employment Division versus Smith, the Supreme Court articulated the test for the Free Exercise Clause. Employment Division versus Smith involved an Oregon law that prohibited the consumption of peyote, hallucinogenic substance. Native Americans said that their religious rituals required the use of peyote, and they brought a constitutional challenge. The Supreme Court ruled against the Native Americans. The Supreme Court said, when it's a general law that applies to everyone, there's no basis for giving an exception for religion. Now, if it could be shown the law was motivated by a desire to interfere with religion, that would be different. Or if it targeted religion, it would be different. But so long as the law applies to everyone, there's no exception to it for religion. And I think this makes great sense. In a country as diverse as ours with regard to religion, it's hard to give exceptions to laws whenever some religion was burdened. Also, then we have to figure out, what do we mean by religion? And if we give an exception for religion, but not for secular beliefs, doesn't that establish religion? What's interesting is, since 1990, the conservative justices have shifted their position. Now they want very much to protect religion, and often comes up in the context of religions wanting to discriminate often against gays and lesbians. Well, this year there have been two sets of decisions before the Supreme Court regarding free exercise of religion. And you certainly see the importance of the shift in the composition of the court in these decisions. The first set of cases involved religious challenges to restrictions imposed because of COVID-19. And there have been 4 Supreme Court rulings about this. Let me tell you about them. You'll see what I mean about how they show the significance of the shift in the composition of the court. The first actually came at the end of May 2020. It was called South Bay Pentecostal Church versus Newsom. When Governor Gavin Newsom imposed his closure orders, part of it said that places of religious worship can't have more than 25% of the usual capacity or more than 100 people. A church in Southern California, South Bay Pentecostal Church, brought a lawsuit that said that violated the free exercise of religion. The district court ruled against the church. The federal court of appeals ruled against the church. And the Supreme Court ruled against the church. It was 5-4 in the Supreme Court. The majority was Roberts, Ginsburg, Breyer, Sonora, and Kagan. The only opinion for the majority was one by Chief Justice Roberts for himself, where he talked about the need to defer to government officials in stopping the spread of COVID. Justice Kavanaugh wrote the dissent. He was joined by Thomas, Alito, and Gorsuch. In July of last year, the court then decided Calvary Chapel, Dayton Valley versus Sisolak. This involved the governor of Nevada imposing closure orders and restrictions, including on places of religious worship. Church brought a challenge to this. The federal trial court ruled against the church. The federal court of appeals ruled against the church. and the Supreme Court did so as well. Again, 5-4. 5 in the majority: Roberts, Ginsburg, Breyer, Sonora, and Kagan. Justice Alito wrote an angry, sarcastic dissent, joined by Thomas, Gorsuch, and Kavanaugh. Now skip ahead to Wednesday night, November 25th, day before Thanksgiving, and the Supreme Court handed down its ruling in Catholic Diocese of Brooklyn versus Cuomo. We're used to major decisions of the Supreme Court coming at the end of June. This was a few minutes before midnight, the night before Thanksgiving. Governor Cuomo in New York imposed restrictions in the state, and they varied depending on the prevalence of COVID in the area. Where COVID was most prevalent, no more than 10 people could gather for religious worship. And of course, there were many other restrictions too. In the area where COVID was next most prevalent, there could be no more than 25 people. In the areas where COVID was less prevalent, it was no more than 50% of usual capacity, and so on. Some Catholic churches in Brooklyn and some Orthodox Jewish synagogues brought a challenge. They lost in the federal trial court. They lost in the federal court of appeals, but the Supreme Court 5-4 ruled in their favor. The 5 in the majority were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Roberts wrote a dissent. Breyer wrote a dissent, joined by Kagan. Sotomayor wrote a dissent, joined by Kagan. But the majority found that there was impermissible burdening of religion by the restrictions imposed by the governor of New York. The final case in this sequence so far was Tandon versus Newsom, the beginning of April of this year. Again, it involved restrictions imposed by Governor Gavin Newsom. The restrictions included a limit on the number of households that could gather together in any home at a point in time. And it didn't matter why the households were gathering. It didn't matter if it was for religious worship, or to watch the Super Bowl, or a book club. The rules applied the same, secular or religious. The federal district court ruled against those who were bringing a challenge. Federal Court of Appeals agreed, but the Supreme Court, in a 5-4 decision, reversed. The 5 in the majority were again Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. The dissent again was Roberts, Breyer, Sonora, and Kagan. What's the difference between the first 2 cases I listed and the latter 2 cases I listed? Why did the first 2 uphold the governor's orders and the latter 2 strike them down? It wasn't a difference in the facts of the case. It was entirely Barrett replacing Ginsburg. In these 2 later rulings show a court that is very inclined to protect religion and give it exceptions from general laws. Just what Justice Scalia said 30 years ago shouldn't happen. The other case with regard to religion, which came down last Thursday, even more fully illustrates this. The case is Fulton versus City of Philadelphia. Philadelphia contracts with private social service agencies to place children in foster care. Philadelphia insists that in order to contract with the city, the social service agency agree not to discriminate based on race, sex, religion, or sexual orientation. Catholic Social Services brought a challenge to this. They said they refused to place children with same-sex couples. They said this was because of their religious beliefs. The federal district court ruled against Catholic Social Services, going back to Employment Division versus Smith. The city says no one can contract if they discriminate based on race, sex, religion, or sexual orientation. This is the quintessential law of general applicability. The United States Court of Appeals for the Third Circuit agreed, but the Supreme Court last week reversed. Now, it's interesting. Justice Alito wrote a 77-page opinion concurring, joined by Justice Thomas and Gorsuch, in which Justice Alito would overrule Employment Division versus Smith and provide much more protection for religions, including when religions want to discriminate. Justice Barrett wrote an opinion, joined especially by Justice Kavanaugh, in which she expressed support for this, but said we don't need to go so far in this case. Chief Justice Roberts wrote the majority. He said, so long as the law is a general law, you can't challenge it as burdening for excess religion, no matter how great a burden it creates. But he said the Philadelphia Ordinance allows the mayor to grant exceptions. There's discretion in the statute for that. Roberts said, since there's discretion in the statute, that then is not a general law, and it then violates free exercise of religion. To be clear, the court did not say that Philadelphia was discriminating against religion, did not say there was any evidence that the Catholic Church or anyone was treated differently than others. What the court said was the very existence of discretion to create exemptions is enough to mean this violates free exercise of religion. I think that this case is important because it does make it easier for religions to seek exceptions from general laws, including from anti-discrimination laws. That's the context for this case and so many of the cases coming up. The desire part of religious entities like the Catholic Church to have exceptions from general laws. And this often comes up in the context of the anti-discrimination laws. As an example, there are many cases pending now that involve bakers and florists and videographers and stationery stores. They refuse to serve same-sex couples, even the law requires it. There are many cases coming up involving employers who want to discriminate in hiring against gay, lesbian, and transgender individuals. What we have now is a Supreme Court that very much wants to come down, and I think will come down, on the side of those who want to discriminate in the name of their religions. There is always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to discriminate. But our society has made the choice, for half a century at least, that stopping discrimination is more important than the freedom to discriminate. I think now, though, the conservative justices on the court are making exactly the opposite value choice. They are protecting the right to discriminate in the name of free exercise of religion. And of course, there's no way to just limit this to those who want to discriminate against gay, lesbian, transgender individuals. What if somebody on the basis of his or her religion says that they don't want to serve Black customers? Or what if someone says it violates their religion to put men and women working together in the same workplace, so they won't hire any women employees? Once the court grants this broad exception to religion from general laws, there seems no stopping point. So I think that's the significance of Fulton versus City of Philadelphia. Now, you might have seen the media stories that portrayed it as not that big a deal or a narrow ruling. I think that's only because of what Justice Alito did in wanting to go much further to change the law. On its own terms, it is important, and it's not narrow at all. Well, the third area that I want to talk about concerns freedom of speech. It's a case that hasn't been decided, but it's certainly one of the more colorful cases of the term and one that will get a lot of attention. The case is Mahani Area School District versus BL. BL was a high school sophomore at a public school in Pennsylvania. She tried out for the varsity cheerleading team. She was disappointed when she learned she didn't make it, but she was again, as the prior year, assigned to the junior varsity. She was then furious when she found out that a freshman had made the varsity ahead of her. She went on the social media platform Snapchat, and she did a short video. On it, she raised the middle finger of both hands, and she repeatedly used a profanity that starts with the letter F and talking about various things in the athletic program of the school. The cheer coach got to see the video at some point, thought it was inappropriate behavior for a cheerleader, and kicked her off the cheerleading team. No other school discipline was imposed on her, and she was told she could try it again the next year. She sued to say that she should get an injunction to reinstate her to the team. The federal district court ruled in her favor. The Federal Court of Appeals agreed, and it came to the United States Supreme Court. On the one hand, this is an easy case. On the other hand, the underlying issue is enormously difficult. Why do I think it's such an easy case? No one was hurt by her video over Snapchat. There's no showing that in any way it disrupted school activities. It was on a social media platform on a Saturday. Admittedly, her speech was sophomoric, but she was a sophomore. On the other hand, the underlying issue is enormously difficult. Should schools ever be able to punish student speech over social media outside of school hours? What if students are using social media to engage in bullying or racial or sexual harassment? Don't the schools then have a legal duty to act? I argued a case about this just a few years ago in the United States Court of Appeals for the Fourth Circuit in Richmond, Virginia. It's a case that arose at Mary Washington University, a public school in Virginia. There was debate on the campus at Mary Washington University as to whether to allow Greek life, fraternities and sororities. 3 women wrote an op-ed in the campus newspaper opposing fraternities on campus. They argued that when there's fraternities, there's greater sexual violence on campus. They were then targeted, and over 700 vitriolic, angry messages were directed at them over the then social media platform, Yik Yak. Some of those messages threatened them with rape and murder. They went to school officials, and the school officials said, it's anonymous speech over social media. There's nothing we can do about it, but we'll organize a sharing circle if you want, where you can talk about your feelings. The school, in fact, posted on its website that since this was anonymous speech over social media, they couldn't do anything. The women sued and lost in the federal district court. I handled the case and argued it on appeal, and I prevailed. The Court of Appeal said that schools cannot be deliberately indifferent to sexual harassment. Title IX of the Civil Rights Act says that educational institutions that receive federal money cannot discriminate based on sex. The Supreme Court has said sexual harassment is a form of sex discrimination. And the law is clear, there cannot be deliberate indifference. And so the Fourth Circuit, I think wisely there said that when speech amounts to sexual harassment, when it's true threats of violence, then it's not protected by the First Amendment. Well, how should schools be able to deal with student speech over social media? It's clear to me if they're not disruptive of school activities, it's none of the school's business. But when it rises to the level of bullying or race harassment or sex harassment, then it's quite different. And then schools have the duty to do something. But that's not what this case is about. And my hope is the Supreme Court will deal with this case quite narrowly based on its own facts without going to the larger questions. But be on the lookout. Sometime either Thursday or Monday or Thursday, likely next week, we'll get that decision from the Supreme Court. The fourth and final area I want to talk about today concerns voting rights. And here there's an important case also to come down in the next 10 days. It's Arizona Republican Party versus Democratic National Committee. Arizona imposed a couple of restrictions in voting. One of them said that a person, would it have the vote counted, can cast the ballot only in the individual's precinct. That if somebody by mistake cast a ballot outside of his precinct, the ballot would not be counted at all. The other provision of Arizona law says that when there's an absentee ballot, it can be turned in only by the person or a relative of the person. Can't be turned in by somebody else. That's prohibiting the practice, sometimes called ballot harvesting. a challenge was brought to these provisions. It was claimed that they violated Section 2 of the Voting Rights Act of 1965. I think of the Voting Rights Act of 1965 as one of the most important federal laws adopted in my lifetime. It was the result of the concerted effort, Dr. Martin Luther King Jr. and others, and the support of President Lyndon Johnson. One key provision of the Voting Rights Act was declared unconstitutional by the Supreme Court 8 years ago. Section 5 of the Voting Rights Act said that jurisdictions with a history of race discrimination in voting had to get pre-approval, technically called pre-clearance, before changing their election systems. Section 4B of the Act specified which jurisdictions had to get pre-clearance, and under the formula that existed, 9 states, almost all in the South, and cities across the country had to get pre-approval before changing their election systems. In Shelby County versus Holder in 2013, the Supreme Court declared the pre-clearance requirements unconstitutional. The court effectively nullified those provisions. Why does that matter? Well, Georgia, for example, is one of the states that needed to get pre-clearance. They never would have gotten pre-clearance for the law they recently adopted, restricting access to voting. The other crucial part of the Voting Rights Act is Section 2. It says that state and local governments cannot have election systems that discriminate on the basis of race or against certain language minorities. It authorizes lawsuits when there's violations of Section 2. Well, the suit with regard to the Arizona law was brought under Section 2 of the Voting Rights Act. The United States Court of Appeals for the Ninth Circuit ruled against Arizona and in favor of the challengers. The Ninth Circuit, in an opinion by Judge William Fletcher, found that the Arizona law had a racially discriminatory impact and also found that it was a discriminatory intent behind it. Judge Fletcher, writing for the court, talked about these additional restrictions in voting in Arizona were likely to have a much greater effect on African American and Latinx voters than they would on white voters. And the Ninth Circuit said that that proven discriminatory effect should be enough to invalidate the law. The Supreme Court granted review. From the oral argument in the case, my fear is that the Supreme Court is going to greatly weaken Section 2 of the Voting Rights Act and make it much harder to use to challenge provisions that have a racially discriminatory effect with regard to voting. Think of the laws that have recently been adopted in Georgia, in Florida, in Arkansas. The law that was adopted in Texas. Challenges brought against all the adopted laws for violating Section 2 of the Voting Rights Act. But if the court greatly weakens Section 2, it'd be impossible to bring successful challenges to those laws. So this case is important, not just for those in Arizona, but for the country in terms of how difficult is the Supreme Court going to make it, maybe even impossible, to sue for race discrimination in voting. In our country, there are now 2 competing narratives with regard to voting. One view, the Republican view, is that voter fraud is an enormous problem, and we need restrictions on voting to deal with the problem of voter fraud. You certainly hear that uttered by former President Trump and his supporters. On the other hand, there's the Democratic view that the largest problem with voting in our country is voter suppression, that there's no real evidence of voter fraud. They point to the fact that the Trump campaign brought 33 lawsuits after November 3rd. They lost 32 of 33. The only one they won was a right to stand a little bit closer to the ballot counters as they were looking at the ballots. We have a Supreme Court that has 6 Republican nominees and 3 Democratic nominees. Are they likely to look at voting the same way as others in their party? Are they likely to greatly narrow the ability to use the Voting Rights Act to challenge race discrimination in voting? So those are the 4 areas that I wanted to talk about. As I said at the beginning, we're mentioning the title, next year is going to be an even more amazing year in the court. The Supreme Court has already granted review in next year of a case coming out of Mississippi, a law that prohibits abortions after the 15th week of pregnancy. I think there's a real likelihood that the Supreme Court is going to use this case as the vehicle for overruling Roe versus Wade. There's a case coming out of New York where New York limits the ability of people to have concealed weapons unless they get a permit. I think we likely see a court to expand Second Amendment rights. You will see stories in the media in the next few weeks as this term ends that maybe the court isn't as conservative as everyone thought. Maybe Justice Barrett won't be as conservative as you thought. Don't be misled by these stories. You never can draw conclusions from a limited data set. We only this year have Justice Barrett on the court for not even quite a full term. I think it's next year that we're much more likely to get the full glimpse how conservative the Roberts Court is, has become, and will be for the foreseeable future. So I said I would talk for about 45 minutes and then take the last 15 minutes for questions, and I think that's where we're at. And I'll take questions on anything with regard to the court.
We are indeed. And thank you for ending on such an optimistic note. Which I think you've been there each time. So a few questions. I'm noting people are sending questions, and I'll try to get to as many as possible. There was a question that was sent to me earlier, which was about Justice Breyer and the pressure, I guess, we're reading about for him to retire. Can you talk about that and what you think will happen with him?
Sure. In March 2014, I wrote an op-ed in the LA Times urging Justice Ginsburg to step down at the end of the term. I said, we have a Democratic president and a Democratic Senate. I said, it looked like the Republicans were going to take the Senate in November 2014. They did. I said, there's no way to know what's going to happen in the 2016 election. That sure was an understatement. And I said, if she wants to be replaced by someone with her values and her views, this is the time for her to step down, because anyone President Obama picked would have been confirmed by the Democratic Senate. I never thought a Supreme Court justice would pay much attention to what a law professor dean in Irvine, California was saying, but I sure drew her ire. She gave many interviews in which she said, some, such as Erwin Chemerinsky, think I should step down, and I'm not going anywhere. She expressed great displeasure with my op-ed from the day that it was written, and she made sure that was communicated to me. She gambled that she'd be able to stay on the court until there was a president with her views to replace her. We lost. Well, I think Justice Breyer needs to learn from this experience. So I wrote an op-ed in the Washington Post, maybe about 6 weeks ago, urging Justice Breyer to step down at the end of this term. I have no idea what Breyer will do. Some have suggested that all these people pushing for his retirement will cause him to dig in his heels. Maybe. Others think that he might step down at the end of this term, or at the very least at the end of next term. Why should it matter whether he goes this year as opposed to next year? Because the Democrats have the Senate at least until January of 2021 when the new senators are sworn in. The current Senate, as everyone knows, is 50-50, Democrats and Republicans. If a Democratic senator from a state with a Republican governor should leave the Senate the next year, the Democrats would lose their majority. I personally think it's important that Justice Breyer step down now when there is a Democratic president and Democratic control of the Senate.
Each year you've told us who you think, whose court it is. So given the most recent makeup and the arrival of Amy Coney Bryant, whose court is it right now?
It's a great question, and I don't think we know. For a long time, I told you it was the Kennedy court. Last year, it was clearly the Roberts court. Last year, Roberts voted in the majority 97% of the time. And last year, you could see it was the Roberts court because he was the swing justice. You had 4 more liberal justices, Ginsburg, Brierson, and Kagan, 4 more conservative justices, Thomas, Alito, Gorsuch, and Kavanaugh, which let Roberts be right in the middle. But now there's 5 justices more conservative than Roberts. So I don't think you can say ideologically it's the Roberts court. But it's not clear who among the 5 is going to be the pivotal justice. Maybe none of them. Thomas and Alito really set themselves apart as the most conservative on a conservative court. They were the only 2 to dissent, for example, last week in the Affordable Care Act case. And it was Thomas and Alito and Gorsuch who really wanted to change the law in Fulton, the Catholic Social Services case. I don't know who among those 5 will turn out to be the leader. And maybe by default, then, we still should be calling it the Roberts Court.
There have been numerous questions as to your thoughts on trying to expand the court in order to address what's happened in the last 2 years.
I personally would favor it, but there's no chance it will happen. Why would I favor it? I want to restore some ideological balance to the Supreme Court. Here's a startling statistic. Between 1960 and 2020, there were 32 years with a Republican president and 28 years with a Democratic president. In 4 years in 2024, we'll have 32 years with a Republican president and 32 years with a Democratic president. That's remarkable. Since 1960, Republican presidents have picked 15 Supreme Court justices, while Democratic presidents have picked only 8 Supreme Court justices. It's a ratio of almost 2 to 1. Also, I think that what the Republicans did in blocking Merrick Garland's consideration, pushing through Amy Coney Barrett, really was a form of court packing. And unless we want to accept a very conservative court for a long time to come, I think a solution is to expand the size of the Supreme Court. The number of justices is not set by the Constitution. It's set by a federal law and can be changed by a federal law. But here's why it won't happen. To adopt legislation in the Senate means overcoming a filibuster. Any legislative proposal, unless it's a budget matter, can be filibustered. It takes 60 votes to overcome a filibuster. If Congress were to try to change the size of the Supreme Court by legislation, Republicans be sure to filibuster this. There's not going to be 60 votes. It's not going to happen.
Anything you can tell us about Clarence Thomas these days? I mean, I know you've mentioned where he is in the court, but has he been more active than usual in writing or participating in oral argument, or is he just where he's always been?
Ideologically, he's where he's always been. He is as conservative as any justice on the current court, as conservative as any justice in history. In terms of participating in oral arguments, the answer is there's been a dramatic change. Why? Until May of 2020, all through American history without exception, oral arguments were held in the Supreme Court's majestic courtroom. The courtroom has always been where the arguments have been held, and certainly in the current majestic courtroom, that's where the arguments have taken place since it was built. And Clarence Thomas virtually never participated in oral arguments. He would go years without ever asking a single question. I remember marking after I argued a case in the Supreme Court a year ago fall, that if you asked me under oath, was Clarence Thomas there that day? I'd say, I just don't remember. Since he asked no questions, I was paying no attention to him. He sits way back, reclining in his chair, and just that was characteristic. Well, in May of 2020, and throughout this year, all of the Supreme Court oral arguments have been held by telephone. And the justices take turns asking questions. It always starts with Roberts as the chief, then Thomas next as the most senior associate justice, going down to Barrett, the most junior justice. And Thomas regularly participates in that questioning. That's a real change. In terms of writing opinions, the justices all write about the same number of opinions. They're generally each assigned one case to write for each of the months of the oral argument calendar. So I don't think Thomas is writing more or less, tends to write more concurring opinions and dissenting opinions than most justices, but not more majority opinions.
I actually heard him say something in a case which was surprising, and that he spoke, but what he said was relatively inane, and so that's why I asked the question. Since he's participating more, are you getting a better understanding of his intellectual faculties and abilities?
I have no question about his intellectual faculties and abilities. On the other hand, he is a very conservative and even radically conservative justice. Why do I say that? Justice Scalia, like Justice Thomas, was an originalist, believing that the meaning of the Constitution is fixed when it's adopted. But Scalia called himself a, quote, faint-hearted originalist because he wouldn't overrule precedent to follow originalism. Justice Thomas has no such reservation. He has said explicitly he doesn't believe that precedent should be followed, that justices should follow the original meaning of the Constitution. So Justice Thomas has said that all of the cases protecting privacy, including abortion rights, should be overruled. Justice Thomas has said that the Establishment Clause of the First Amendment shouldn't apply to state and local governments, so state and local governments can create their own churches or require religious participation. Justice Thomas has wanted to enormously limit Congress's power to regulate commerce among the states, even though it means overruling precedent. So ideologically, he is not just conservative, but radically so.
There have been a few questions, and the answer is probably going to be the same, but maybe it's just for your input. Should we have a limit on the term of Supreme Court justices? Yes,
I would favor 18-year non-renewable terms. Why? Well, some of it is life expectancy is a lot longer today, thankfully, than it was in 1787 when the Constitution was written. In 1787, the average life expectancy was 36 years old. Think about it in terms of the justice we were just talking about, Clarence Thomas. He was confirmed for a seat in the Supreme Court in 1991 when he was 43 years old. He's already going to be a justice now for 30 years. If he stays on the court until he's 90, when Justice Stevens stepped down, Thomas will be a justice for 47 years. John Roberts, Elena Kagan were 50 when they were confirmed for the Supreme Court. If they stay till they're 90, that's 40 years. I talked about Barrett being 48 years old when she was sworn in. That's too much power in one person's hands for too long a period of time. Also, too much turns on historical accident. Richard Nixon got 4 vacancies to fill in his first 2 years as president. Donald Trump got 3 vacancies in his 4 years as president. Jimmy Carter had no vacancies on the Supreme Court to fill. 18-year non-renewable terms, if they're staggered, would mean a vacancy every 2 years, and every president had the same ability to influence the outcome with regard to the composition of the Supreme Court.
But again, to achieve that, you would need to have, I assume, congressional approval, and I assume that's not going to happen because whoever's in power is not going to allow it.
I think it would actually take a constitutional amendment, and I think there could be bipartisan support for it, but it's so hard to amend the Constitution. It takes 2/3 of both houses of Congress and 3/4 of the states. It really requires a constituency that cares so much about this issue to push it forward. I don't see what that constituency is on that issue.
We're almost out of time, so I'll try to get to 1 or 2 more questions. Neil wants to know how the justices in general come to their decisions. Do they talk to each other? Do they make their own decisions? And then, Roberts pulls it together. How does that process work?
Every week that the Supreme Court holds oral argument, they also hold a private conference at the end of the week. The only people allowed in the conference are the justices. No law clerks, no secretaries. And the Chief Justice begins by stating his views of the case. And then they go down the line with the most senior Associate Justice Thomas speaking next to the most junior Justice Barrett. And they vote. If the Chief Justice is in the majority, the Chief Justice assigns who writes the majority opinion. If the Chief Justice isn't in the majority, the most senior Associate Justice in the majority assigns who writes the majority opinion. They then circulate the opinion to the other justices, The other justices can sign on or ask for changes or write their own opinion. They can change their mind. Apparently, from what the justices say, most of the conversation goes on at that conference where all the justices are present, but there's nothing to stop the justices from talking separately to one another as well.
In our last minute or two, can you tell us about your new book that's coming out in the next month or so?
I'd be thrilled. Short of talking about my new granddaughter who was born on May 12th, there's nothing I'd rather talk about than this book. The book is called Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. It's a focus on the Supreme Court and its decisions about policing and race in the United States. Interestingly, I signed the contract to write the book in January of 2019. And then, of course, all of the events happened last spring that make this timely. The thesis of the book is that the Supreme Court over the course of American history has not enforced the provisions of the Constitution, protecting the rights of those accused of crime and criminal defendants. Instead, what the Supreme Court has done is very aggressively empower the police. And the book tries to look at the sweep of American history from the beginning of the Constitution through this year, and how the Supreme Court has dealt with issues, policing, and how much the Supreme Court is responsible for race-based policing that exists today in the country.
Well, we hope to have you back for a book launch so we can learn more about the book. And I want to thank you again for giving us a great review as to important cases. We have to be educated to understand what's going on, and you give us the understanding and the will and the interest to read further. So we'll look to see how these two cases come out in the next 2 weeks, and we'll understand the implications of them because of your excellent presentation. Thank you, everybody, for being with us today, for learning more about our system. You know, people ask, like, what can we do? Like, I think one of the problems is that we all feel powerless. We certainly feel powerless when it comes to Congress, and we feel even more powerless when it comes to the Supreme Court. I don't know if there's anything you could share at the end. Tell us what we can do in the face of decisions that we don't like on either side, I guess.
To get involved. Ultimately, who's on the Supreme Court as a result of who's the president, who's the Senate. Get involved in those elections. And if the Supreme Court isn't the vehicle that we want for rights, well, then let's look to other vehicles. Let's do more with regard to state courts and using the state courts to protect rights. And that turns on who's the governor in our state and putting pressure on the governor to appoint people. We're going to need to turn more to the political process, to legislatures, state, city councils to protect our rights. We need to get involved in order to do all that. And often getting involved is working in organizations with like-minded people. So whether you're liberal or conservative, it's so important to get involved on these issues.
Thank you. So on that note, go out and get more educated on the issues. Thank you, Professor Dean Chemerinsky. We look forward to having you back soon about your book, and then next year for our annual tradition. Thank you, everybody, for being with us. Lots of programs this week. Please join us at CSP, occsp.net. See you guys soon. Be safe. Bye-bye.